Okay, we're going live. Hello, everyone. This is Michael Saltzman from Blue Sky Bio. I hope everybody is staying safe and healthy and at home during this time period. We are continuing our viral dental education webinar series. We continue to have a lineup of fantastic speakers presenting on a wide variety of topics throughout the upcoming time period. Today, we actually have a double header. We have the webinar presentation right now, and we have another one scheduled to start at 1 p.m. Eastern Time. Dr. Russell Schaefer will be presenting on making dentures in-house. Please follow our webinar schedule listed on blueskyplan.com/webinars 2020 and on the Blue Sky Bio user group and the Viral Dental Education Facebook group as well. All of the webinars, as usual, are recorded, so if you're not able to attend, you could watch the recording. We send CE credits to everybody who attends live automatically. They will arrive within 2 weeks' time to your email, so please be patient and check your email. If you're not able to attend live, then as usual, you can watch the recording, complete a short 10-question multiple choice test, and then we'll be able to send you the CE credit. So all this information is on blueskyplan.com, webinars 2020. If you have any questions during the presentation, please enter them into the question and answer box. We are going to save at the end. Today's presentation, or this presentation, is going to be presented by Ms. Helen Bloch. She is a super lawyer consulting companies and startups on a wide range of different topics, including contracts, building startups, and she specializes in employment relationship and is involved in the creation of handbooks, various policies and procedures. She's the president of the Decalogue Society of Lawyers and has been awarded a long list of various honors, accreditations, recognitions, and lectures on these different topics. She will be discussing today employment law and your dental practice, brushing up on what's new, general information regarding employment and laws, but also specific information regarding to the current situation, and of course, Corona. Helen?
Thank you very much. Well, I am an optimist, a glass half full person, and because of that, I'd like to start this presentation with what normally takes place in the employment environment and what a lot of the employment laws are that might affect your practice on a day-to-day basis, because I see a light at the end of this tunnel, and it's important to know what the policies and procedures should be in your practice on an ongoing basis. And then at the end of the presentation, or I should say more toward the middle and going on toward the end, I will focus specifically on Corona and distinguish the various laws that I discussed in the beginning of the presentation, how that differentiates with what we need to do with regard to Corona. So let's start it out with an example, something that I see commonly, and that might be common in your dental practice, which is you have a dental practice that between your part-time and full-time employees, you have, let's say, about 15 employees. You have a busy practice, and you as the dentist don't run the general day-to-day measures, but really focus on patients and patient satisfaction and building your practice. And so your office is nice and robust. It's not quite big enough to have an independent HR coordinator. So you have an office manager who also doubles as an HR person who you rely on heavily to run the day-to-day affairs of your practice. And in doing so, you know, you were told by whether your insurance company or your payroll provider that it's very important to have an employment manual or some kind of policies and procedures in place. So you rely on your office manager to gather up all that information and to put together an employment handbook. And you probably flipped through it, but you probably didn't read it in detail. And so a lot of things just sounded really nice, and you didn't know, or you didn't even really think about whether by law you need to have it in there or you don't have it in there, but you included a lot of things that you thought based on the recommendation of your office manager should be in there. So for instance, you might have a policy in there on family medical leave, FMLA. And so you have, in addition to this, as I said, a very nice practice, you have a fabulous hygienist. And everyone knows in the dental world that hygienists, a good one, is very hard to come by. They're in high demand. And you love this person. She cleans teeth so well. Your patients love her. They've flocked to your practice because the word has gotten out that their teeth are so clean from this hygienist, that she's been with you for a long time, and she's really helped you, build your practice. She's been with you for, let's say, about 10 years, and she's just fabulous, an integral part of your business. And one day she comes to you and she says, I've got some bad news to tell you. I have breast cancer, but the good news is the doctors tell me I'm going to be okay, but I need to take some time off. I have to have surgery. And because of this, I happened to flip through the handbook and I saw that, you offer family medical leave. And so I'm going to need to take advantage of that. And your instinct and your reaction is, oh my God, that's horrible. Of course, whatever we can do to help you and to help you get past this, of course, sure, we'll provide that to you. And at the time, you're really just thinking about, oh my God, what am I going to do without her? I want to keep her. And you're really not thinking what that means, family medical leave. And so really what now happens, because you've provided family medical leave, is that she gets 12 weeks off to recover from a health condition. And you also say, she says to you, listen, I know I have about, 2 weeks of paid time off, and I'm going to use that. And you say, great, that's fine. And you know what? Because we love you so much and you're fabulous and we just want you to get better, we'll give you another 2 weeks. So this way you have a month of paid leave and everything is great. Okay. She goes off on leave, and she's off for 1 month, 2 months. Around the 2-month mark, you realize this is really tough on my business. It's really hard. I have to bring in another hygienist because the other hygienist I have just can't fulfill these needs. So I've got to bring in someone else. It's tough scheduling patients. Some of my patients have left because she's not there right away, and they need to get their teeth cleaned. And then as my new hygienist gets onboarded, people start to like her. She does a good job as well. And so you start to get to a status quo, and you start to get into a routine where you don't really need this other fabulous hygienist anymore, but you've already committed to FMLA. So she has another month that she's off, and she calls you at the end of that 3rd month because it's 12 weeks of leave. And afterward, she needs to be restored. And she says, I'm doing so much better. My surgery went well, but my doctor says I need another month, which would be 4 months. And you say, okay, well, let me just get back to you on that. And you think about it and you talk to your office manager and you realize, hey, I can't give her another month. This is ridiculous. We're already paying for another person. I can't even imagine bringing her back on. I don't want to fire the other person. What, then I got to pay unemployment for that other person. And my patients have already adjusted. I don't need her anymore. And so you call her back and say, you know what? We love you, but we're okay right now. And it's so easy for hygienists to get business. You'll find another job. We'll give you a fabulous recommendation. You just take care of yourself. But, I don't think we can give you another month off. We need you to either come back or I'm sorry, we'll give you a great recommendation. I'm sure you'll be able to find another job. Okay. And what happens? You find yourself with a big fat lawsuit for discrimination. And why is that? Let's unpack this scenario a little bit. First of all, family medical leave. Let's start there. And you've been distributed with a handout that, let me make sure you can all see.
Yeah, I sent the link to everybody, and if you want to pull it up on your screen, you could share your screen.
Okay, that's what I was just about to do.
You should have the links to the 2 relevant documents in the messaging application for the webinar.
Okay, so can you see that on my screen?
Yeah, we could see that.
Okay, fabulous. Okay, so let's start a little bit with talking in general about employment policies and procedures. So as I mentioned in my scenario, you really didn't pay attention to your employment policies and procedures, and that happens pretty often in small businesses. They rely on their insurance companies, or they make it a manual from a paycheck service that provides a manual, and there's a lot of stuff in there that might really not apply to your practice. An employment manual is really supposed to be the rules of your practice, and it should really be tailored to your business, whatever is specific and unique to your business in particular. And there's some things by, let's say, state law in many states now that have to be in there, such as sexual harassment, discrimination. It wasn't always the case where there were specific things that actually needed to be published or provided, other than certain posters that have to be in the employment practice, and we'll get that actually toward the end of the presentation. But other than those posters, like under the Fair Labor Standards Act that you have to, by law, post under federal law, and federal law applies to everyone. So keep in mind you have state laws and you have federal laws. So federal law is the laws of the United States of America, and that applies to everyone if it's applicable to you. And here's what I mean. For instance, when I talk about Family Medical Leave Act, that is a federal law. But in order to have to provide family medical leave, you have to have 50 or more employees, as I show, right here on my handout. And just so you know, this handout is not meant to be exhaustive. This does not have all the requirements under Family Medical Leave or the Americans with Disabilities Act. This is just a few little tidbits that I thought were important to share. So again, with regard to my handout, my presentation in general, I'm not providing legal advice, just general information. And especially you need to check the law in the state in which you live, because you have federal laws, and again, you have state laws, and you might also have local laws that apply to you, and they're going to vary from state to state. So you always want to know, what is the federal law? Does it apply to me, such as does family medical leave apply to me? And what are the state requirements? And a lot of times we have federal employment laws that have large numbers, and when I mean large numbers, not necessarily an employer like GM would think they're, it's large, but I mean, for dentists in general, a large dental practice would be 50, and probably most dental practices don't have 50 employees. So probably most dental practices don't have to provide family medical leave. And that's why I say it's important to really look through your handbook, because under some state laws, you might have to provide some form of leave, but it might not be the same as required by federal law. And so if you have in your handbook that you're providing family medical leave, well, you've now given that benefit to your employee. And so under family medical leave, it applies to employers with 50 or more employees in a work site. And it gives 12 weeks of job protected leave for a serious health condition of the employer or certain members of the employee's family. And this is going to be relevant when we talked about Corona, because now some of the family medical leave has been expanded to employers irrespective of size. So that's why I thought, even though FMLA in general might not apply to you, it's important to understand it, because some of it now might apply to you. And we'll get back to that in the end. So in any event, in order for your employee to be eligible for family medical leave, if let's say you do have a practice that's large enough, you have to have, the employee has to have worked at least 1,250 hours in the 12 months prior to the request being made. You have to keep the individual with their same benefits and on the employment health plan that you would have in place. And then once that FMLA is up, you have to restore the employee to the same or an equivalent position when that leave is over. So in the example I gave with your hygienist, when the FMLA was up, you needed to have brought back that hygienist to the same or an equivalent position with the same pay, with the same benefits, etc. Now, in order to be eligible for FMLA, there are certain notice requirements that the employee is required to provide certain notice, and also a doctor's certification. And there are various forms that the employee needs to fill out and the doctor needs to fill out in order for that individual to be eligible to receive FMLA. And when it comes time for the employee to come back to work, the employee also will need to provide, or the employer can require that the employee provide a certain medical certification and a fitness for duty certification upon return to the employment. And again, that could be on specific forms, and certain information can be requested. But keep in mind though, even if you're an employer that's not large enough for FMLA, you've got to look to your state laws. A lot of states have passed certain medical leave laws that for a certain amount of weeks, the job is protected, and also there is a certain amount of paid sick leave. So even if you as an employer don't have or don't give your employees, and when I say employees, I don't just mean full-time, I mean all employees, including part-time employees, there are state laws that require you to provide a certain amount of paid leave, even for your part-time employees. So you really need to check those local laws. And it might not even be the state in which you work. It could be local. So for instance, I'm here in Illinois, and I specifically practice, my office is in the city of Chicago. The city of Chicago has a paid sick leave ordinance, as does Cook County, the county in which I practice. And so that could be different than even a different county within the same state. So you really have to be familiar with what applies to me both locally and nationally. Now, in addition to these various rights to care for, let's say, yourself or a family member, pregnancy. Pregnancy also, most states, in addition to the FMLA, do provide certain pregnancy leaves. And now, again, if you remember my scenario, your employee or your hygienist was able to said that she couldn't come back after the family medical leave was up, meaning those 3 months. She needed 1 more month. And that's where I said you expose yourself to liability. And why is that? Because of the interplay between the Family Medical Leave Act and the Americans with Disabilities Act, which is on the bottom of page 1 of my handout. The Americans with Disabilities Act is a federal law that applies to employers with 15 or more employees. And remember, employees includes your part-time staff, your part-time employees. And so even though FMLA in this situation might not have applied to the place of employment, the Americans with Disabilities Act would apply to this scenario, because remember, I mentioned that the dental practice has about 15 employees. And so under the Americans with Disabilities Act, one cannot discriminate against individuals with disabilities. And disability is really defined as a physical or mental impairment that substantially limits one or more major life activities. So in general, not talking about Corona time now, but something like a virus like the flu would not be considered a disability because it's transitory. It's not permanent in nature. It's something that unfortunately you have it, but then you get over it. It does not substantially limit or impair a major life activity. So in general, the flu would not fall under the Americans with Disabilities Act protection. But in the scenario I gave you, cancer certainly does. And because this employee came to you and said, you know, my doctor says I need 1 more month, she was really asking for an accommodation, to make a reasonable accommodation for her so that she could recover and get back to work, because cancer does affect a major life activity. And so in that scenario, before deciding to terminate her, you would have had to engage in what's called the interactive process. You would have had to ask her, is there an accommodation, a reasonable accommodation that we can provide to you that would help you recover or help you or allow you to continue to work as a result of this disability? So anytime an employee comes to you with a disability, you have to, by law, engage in the interactive process with the employee to determine whether there's a reasonable accommodation that can be provided to that employee to allow that employee to be able to perform the essential functions of the job. And that's a key language. And the only time you are not required to provide that accommodation is when it's going to cause an undue hardship to the business. And so when this employee asked you for that next month off, you were not allowed by law to say no right away. You have had to say, well, you know, please give me the notice, give it to me in writing. You would need to ask them to sign some form of a HIPAA so that you can contact their doctor and send a notification to the doctor to ask for what, if any, accommodation she can be, you know, can be provided to her. And then, for instance, if the doctor would say, you know, she needs an indefinite leave, then that's your opportunity to say, hey, an indefinite leave would be an undue hardship to my business, and I can't provide that accommodation. But that's part of what's called the interactive process. Now, another thing that's a little bit interesting is under the Americans with Disabilities Act, you can't require medical examinations of employees unless it is specifically something that is tied to your business. It has to be, you have to have a genuine need for your business for that medical examination. So if, let's say, you have certain lifting requirements or whatnot that your employee has to do, you need to offer that employee a job and condition that offer of employment on passing, let's say, a medical examination. But you can't just willy-nilly require a medical examination. And so the question of, can I take an employee's temperature, is questionable under the Americans with Disabilities Act, because that would constitute a medical examination. So for instance, in the example of the seasonal flu, you could not take the employee's temperature because that would constitute a medical examination that I don't think you would have the right to ask of your employee. Because generally you cannot ask your employees about disabilities. You have to wait for them to come to you. Now again, I'm going to distinguish this when we get to specifically Corona, because that is something where the Americans with Disabilities Act is treated differently for Corona, because in the Corona situation, there's a direct threat. And when there's a direct threat to the health and safety of others, then you can perform certain medical tests under that situation. So if, let's say, you perform some type of a medical examination that is consistent with your employer's business needs, you have to keep that in a separate file. It's confidential. Medical records that, let's say, you receive from your employee as part of the interactive process, again, are confidential. For you guys, I know that's easy to understand because you're used to dealing with HIPAA. For a lot of my clients, it's not so easy to understand. So you might want to keep a separate file that's not part of the personnel file in which you keep medical records of the employee. Because if you have certain key employees that have access to the personnel files, you don't want them to have access to the confidential medical information of your employees. So if in fact you do have to provide a medical examination, or let's say the employee requests an accommodation, and you require medical documentation or certification, you do have to keep that in a separate file. And those with only a need-to-know basis should have access to that. Also, you have to be very careful to not let other employees know about the confidential, health information that you might be privy to about your employees. Another thing that you have to understand is, okay, so you say, I have a small dental practice. The Americans with Disabilities Act does not apply to me. I don't have 15 employees. Well, you have to understand, again, that's a federal law, but there are also state and local laws that might apply to you. So for instance, most states have human rights laws, and the human rights laws do include protections against discrimination based on sex, gender, national origin. And a lot of times those local laws are more expansive than federal law. So for instance, I can tell you in Illinois, come January 1st before Corona, I was extremely busy because the Illinois Human Rights Act was amended to apply to an employer irrespective of size. So even if you had only one employee, as of now in Illinois, all of the discrimination laws under the state of Illinois apply. And it's, as I said, it's even broader than under federal law because, for instance, marital status is a protected classification, sexual orientation, gender, transgender, now even regarded as. So if, for instance, let me tell you what regarded as means. Let's say you have an employee who is somewhat effeminate, uses their hands a lot like I do, and it's a male employee. And you have other employees who kind of make fun of that person and make jokes with sexual innuendos. And it turns out the employee's not gay, but he was regarded as being gay, and therefore subject to somewhat of a hostile work environment because he was regarded as. That is now a protected category. So that individual didn't have to necessarily be gay, but been regarded as being a member of a protected category. And all the various discrimination laws apply now to that individual under the local law. So you also have to check the ordinances. So you might say, okay, I'm in a state that is not that broad as Illinois, so I don't have to worry about it. But maybe there's a local law. So for instance, in Chicago, before Illinois passed this law, a lot of people filed discrimination claims before the City of Chicago Commission on Human Relations because there was no magic number of employees. So you really also have to check the local laws of where you are, where your practice is located, because it might apply to you even though your state or your federal law might not apply. And so you have to really be cognizant of that. Pregnancy is another area. A lot of jurisdictions now are passing pregnancy laws that are very, very expansive. It could apply to any employer irrespective of size. So not only does it preclude discrimination based on pregnancy and pregnancy-related conditions, but it could incorporate FMLA requirements. It could provide that when your employee comes back to work after pregnancy, you have to make reasonable accommodations in the workplace, such as time to express milk. And even if your employee is, let's say, an hourly employee, and I'll get to that in a little bit when we talk about some of the wage laws, you might have to pay the employee for the time it takes them to express milk. And you have to provide a private location, not a bathroom, for them to express milk. And so it's important to really become familiar with all the different nuances as an employer for these various local laws as well. And so we touched on wages a little bit. The Fair Labor Standards Act is a federal law, and this one applies to all employers irrespective of size. And the Fair Labor Standards Act does have minimum wage requirements, and the minimum wage under federal law, I can tell you, is far lower than under the laws of a lot of states in this country. So again, that's another place where if you have hourly workers, you really need to understand what are the minimum wage requirements in your jurisdiction. And some of them are also being phased to go up every year as well. So under the Fair Labor Standards Act, which again applies to all employers irrespective of size, for any hour worked over 40 in a given work week, you have to pay time and a half for any employee that is not exempt from overtime. And here's what exempt versus non-exempt means. A lot of employers, and I see this across the board, make a mistake by saying, oh, this employee is exempt because I pay him a salary. Well, paying a salary is not determinative of whether someone is exempt from the overtime requirements. Paying a salary is only one of several tests used to determine whether or not someone is exempt. So someone is exempt from overtime, and again, I'm just giving you generalities, not really specifics. Generally, someone is exempt if, let's say, they have a professional degree or a license. So if you hire a dentist, that person is going to be exempt as long as you pay them a certain salary because they fit the professional exemption. So you really need to look at the duties and also whether or not the person is paid a salary. So your secretary, you might pay your secretary the same salary every week, but if your secretary is doing menial tasks, then that secretary is not going to be exempt from overtime. Your office manager that I mentioned to you in the example before, your office manager, if your office manager is paid and meets the salary requirements and truly runs your office, really as a manager, decides who should be hired, who should be fired, what the policies and procedures are in the workplace, then you're probably safe with treating your office manager as exempt, okay? But unless an employee is exempt, you better make sure to keep track of all the hours worked. And even for the exempt employees, you need to keep track somewhere of how many hours they really are working per week, because if you are ever under the investigation of the Department of Labor, you need to provide that documentation and support. And I could tell you it happens. Right now, I do have a client who's in a medical related field that had a disgruntled employee who did something really horrible that was terminated, and that person went to the Department of Labor, made a complaint, and now we're in the middle of an audit, and we have to justify why our certain employees we categorized as exempt, why some are non-exempt. We have to provide job descriptions for all the various employees. We've got to provide the hours they worked, including for those who we treated as exempt. So especially for your quote unquote non-exempt employees, you've got to keep track every day of when they come in, when they leave. If you give them an unpaid, if you don't pay them for lunch, then you got to keep track of the hours that they stop working. And again, the only way to not pay them for lunch, if you don't pay for lunch, is to make sure that lunch is an uninterrupted break. But if, for instance, someone is in, let's say, your office kitchen, and you have occasion to go in there and say, hey, Sally's busy up front. Do you mind just, the reception desk for just 2 minutes? And it's only 2 minutes. And then they go back to eating lunch. You've interrupted their lunch, and you better pay them for that lunch. So in order to not pay for lunch, it has to really be an uninterrupted lunch break. But in any event, you got to keep track. And if, let's say, you know, you're a nice guy, which I'm sure you guys all are nice people, and your employee one day comes to you and says, listen, my kid has a soccer game. Can I leave early? I'll make up the time. And you say, sure, of course, no problem. So on Friday, the employee leaves, let's say, at 2 o'clock. And the next week, they make up the time, which means in the next week, they worked over 40 hours. Well, you better pay them overtime for all that time they worked over 40 hours, because the Department of Labor doesn't care that in the prior week they worked less than 40 hours. They go week by week. So if you want your employee to make up that time, you do it in the same week. You say to your employee, you're leaving early Friday, come in a little earlier on Friday or work a little later on Thursday of the same week. And if you don't do that, then oh well. Don't have them make up the time in the next week, because then you better pay them time and a half for all hours worked over 40. So there are also various state and local wage hours. So for instance, you know, in most jurisdictions, if someone has accrued paid time off and they leave the job for whatever reason, you've got to pay them that accrued paid time off, because that's part of wages. And if you don't, you violate the various laws that are applicable to you for failure to pay wages, which can be pretty steep. And also a lot of states have expense reimbursement laws. And this is going to become very crucial in the time of Corona. So under those various state expense reimbursement laws, and I know California and Illinois are two of the states, and those laws are very, very similar. The Illinois law really tracks the California law, because California was first, but there are other states now that also have expense reimbursement laws. You have to reimburse your employees for expenses that accrue for work. So for instance, if your employees, you contact them on their private cell phones, and you contact them often and you text them often, you might need to help pay for some of their cell phone plan, even if it's a shared family plan. You know, you might need to reimburse them for those costs. So you can have, and you should have, an expense reimbursement policy in place, and that expense reimbursement policy should specify what expenses are reimbursable, what aren't reimbursable. But again, if you are requiring your employees to incur expenses, you can't have an employment policy that says no expenses are reimbursable if you're requiring your employees to incur work-related expenses. And so what's going to become relevant when we talk about Corona is a lot of folks are working from home. You might have your office manager calling patients, rescheduling them, scheduling emergency patients, etc. So if they're working from home and they're using their home computers, their home internet, their printing paper, you should be reimbursing those expenses, and you should be thinking about what policies and procedures we should have in place to reimburse those expenses and give guidelines to your employees if you're in one of those states that requires reimbursing expenses. Because if you don't, you could then be penalized under your various state laws, and possibly even under the Fair Labor Standards Act, for not paying wages to employees. So why don't we turn a little bit, now that I've talked about the basics, let's talk a little bit about all of these various laws that are now in place as a result of Corona, and what is some of the distinction between what's usual under the laws that I've explained and now under Corona. So now, in our new state of affairs, President Trump signed into law after the passage from Congress of the Families First Coronavirus Response Act. And the Family First Coronavirus Response Act has essentially two significant sections. It has a paid time leave section, and it has a family medical leave section. And these laws now apply to any employer with 500 or less employees. So whereas I talked about before, FMLA only applies to 50 or more, this new family medical leave under the Families First Coronavirus Response Act is going to apply to all employers. So, and there again, so let's talk about the first component, which is the paid leave component. So if, for instance, you don't have telework for your employee, or your employee cannot telework because either they are sick themselves with corona, they've been advised by a healthcare provider to self-quarantine, and for whatever reason they can't do telework, or you don't have telework for them. They are at home caring for a child whose school is closed due to COVID-19, or they're experiencing some other kind of condition that the Centers for Disease Control or the U.S. Department of Health and Family Services says they should be home for. This paid sick leave applies to them, and it applies to all employers, all employees, so long as they've worked for you basically from March 1st on. So for the last 30 days. And what basically it does is that it gives them all of their pay. And so if, let's say, you have a full-time employee, they would get their pay. If it's a part-time employee, you would have to figure out the average number of hours they worked in a given week, and that's the amount that they would be paid. But there are certain caps. And because there are certain caps, which is in this employee rights, which is my second handout right here, and it specifies the different caps, an employee might choose to use, if they have paid time off, their paid time off. But as an employer, you cannot require the employee to use their paid time off. It's only if the employee asks you, can I use my paid time off? You've got to give it to them. If they don't ask, you need to offer them this paid time off for 2 weeks, okay? And I don't know why, but for whatever reason, the federal government, in their infinite wisdom, decided that for certain types of reasons, such as if you are quarantined, you have COVID-19, you're experiencing symptoms, the rate of pay is higher. It's 100%, capped up to $511 daily, but it's a little lower. It's 2/3 if it's for another reason, such as caring for your child, okay? But there's also the family medical leave component. The family medical leave component is 12 weeks. It's 12 weeks of job protected leave. The first 2 weeks of those, you're gonna use that paid time off that we just talked about. And for the remaining 10 weeks, you are going to pay that 2/3 of the salary, capped at $200 per day, or $12,000 in total for those 12 weeks that the employee is going to be off of work as a result of COVID, essentially for any reason. And now we have a lot of states, including Illinois, which the governor has basically said, unless you're an essential business, like lawyers and dentists, you need to stay at home. So this now applies to probably most employers across the board. Now, to offset some of these required payments that employers are now required to make, there are tax credits. And so the tax credits are set to offset these requirements under the Families First Coronavirus Response Act. But remember, in order to get this credit, you've got to keep certain documentation, just like under regular FMLA that I explained. So you're going to need some sort of, doctor certification if it's because someone has COVID or their child. But remember, doctors are incredibly busy right now. So all those forms under FMLA or under the ADA, you may have had them fill out before, are not going to fly. You have to be a little bit reasonable. And so maybe just an email from the doctor's office or from a health clinic will suffice under the documentation. If it's because the child is out of school, you need to keep some kind of notification from like the government that schools are closed or from the child's school. But you need to have documentation showing why the individual is off of work. So you need their name, the dates that the leave is required, the qualifying reason why the leave is required, and some sort of statement from the employee that they can't telework. So in order for you to get your credits, you do have to keep track of these documentations. Now let's talk about exams. Remember, I said before, for the flu, you really shouldn't be taking your employee's temperature, and it's a medical exam that probably will be discriminatory under the Americans with Disabilities Act, that you single out an employee and say, hey, you don't look so good today, let me take your temperature. Well, now under COVID, you are allowed to take an employee's temperature. You still have the requirement to keep that confidential in a separate medical file, but because it is a direct threat to the place of employment, according to the CDC, you can take an employee's temperature, you can request information from the employee, such as where did you travel, where were you? Those kind of questions under normal circumstances, you cannot ask an employee. That would invade the employee's privacy, but nowadays you can ask someone about that. The Equal Employment Opportunity Commission, the EEOC, which is the governing body that actually governs Americans with Disabilities Act, sex harassment cases, etc. They now have put out guidelines that it's okay to ask these questions. It will not be a violation of the Americans with Disabilities Act. So, you know, you can also ask employees if they have symptoms of COVID-19. Now, if an employee, for instance, it turns out does have COVID-19 and you know about it, you can't tell the rest of your staff that this person had COVID-19. You can say an employee was diagnosed, but you cannot state the name of the employee. You have to keep this confidential. And so another thing which you should be aware of is under this FMLA, you've got, as I said, FMLA in general, you've got to restore the employee to their position. Now there is an exemption. There are some exemptions for smaller employees. So for instance, an employer that has 25 or less in employees, you don't have to restore that employee who is on the family medical leave under the Families First Coronavirus Response Act to their regular position if, for instance, that position is no longer available because of Corona or because of economic reasons caused by Corona, but you still have an obligation, even for a smaller employee who's 25 or less employees, you still have to call, if let's say magically in the year business picks up and that position opens, you have a responsibility for a year to call back that employee and say, hey, we have a position that opened. Come back now, come back to work for us. So even for employers with 25 or less employees, they still have to keep this in mind that if something opens, if they ended up eliminating that position, to call back that employee. Another thing, employers with 50 or less employees. According to these new regulations, they do not have to provide the paid leave or the FMLA if it jeopardizes the viability of the business as an ongoing concern of the business. They do not have to provide this FMLA. However, in the same law, it says that the Department of Labor will provide regulations as to what constitutes this small business exemption for the 50 or less employees. And in that same vein, the Department of Labor says, don't contact us, we'll contact you. So don't ask us whether or not you get the exemption. So this is causing a lot of ambiguity, a lot of questions, because employers don't know, am I going to be exempt, am I not? And something that you have to keep track of. Today is March 30th. I would figure out very quickly whether you want to provide these benefits or not under the Families First Coronavirus Response Act, because like all of these various laws that I have discussed, there are strong retaliation and discrimination provisions. And the reason why I say figure it out now is because if you think you're not going to be able to keep your employees and provide these benefits, you might want to think about laying them off now. Because after this goes into effect, this Families First Coronavirus Response Act, as of April 1st, there are retaliation and discriminatory provisions in there. So for instance, on April 3rd, you realize, hey, I can't do this. I'm going to have to terminate my employee, and your employee says, you know, you don't think about it, and your employee comes to you and says, hey, I understand, you know, Trump passed this law. I want family medical leave. You know, I can't work and there's no telework. Give me family medical leave. And you say, hey, sorry, they might have a retaliation claim. And you don't even want to get yourself in the position as to whether you were justified or not under this small business exemption, because that can lead to litigation and you might have to pay for that decision. So I would say figure it out now before the law goes into effect, if you can keep your staff or not. Now, as of Friday, in addition to the tax credit benefits that are in the Families First Coronavirus Response Act, I know Trump passed a huge stimulus plan. that gives SBA small business, under the Small Business Administration, small business loans to employers to be able to provide the expanded coverage for family medical leave and also paid sick time. And in fact, it has even sent the message that if you did before terminate your employees recently, bring them back. And if you bring them back and give them these benefits, as long as you keep these employees, we will forgive the loan. So we will give you a loan to pay your salary, your payroll, your mortgage, your rent, etc. But you keep your employees. And if you keep your employees, we will forgive the loan. Now, again, I don't know what that involves. I don't know what that requires. I'm not a CPA. I don't really know how that works. I still have to get up to speed myself on what came out on Friday. But that is my limited understanding. So I think I have talked long enough, and I would be happy to open it up to questions.
Okay. Let's get started with some questions that came in. And if there are additional questions, you could add them into the question and answer box and we'll field them.
Now, can you guys still see me? For some reason, I can't see myself.
Yeah, we could still see you.
It's okay.
We could see you and we could see your desktop. If you don't need to share your desktop, then you could stop sharing your desktop. Either way.
Oh,
anyway.
Sorry. Let me get off that then. Yeah, I'll put that back up maybe.
The first question that came in is, which version of the FFCRA law takes precedence? The federal versus my state's version?
I am not necessarily familiar with the states by state to state, so I can't necessarily answer that, but what I could say is that federal law generally trumps, and federal law, remember what I said in the beginning of my presentation, if you have the number requirements, federal law applies to each and every employer. So for instance, in the context of the Americans with Disabilities Act, you have 15 or more employees, it's going to apply. Fair Labor Standards Act, there are no minimum requirements. So Fair Labor Standards Act applies to all employers across the board. So federal law, the Families First Coronavirus Response Act is going to apply to all employers across the board, irrespective of size. But remember, there are certain carve-outs for employers with 25 or less employees and 50 or less. And there is a max too. So I guess, you know, employers with 500 or more, it doesn't apply to, although certain employers have applied that. But my guess is that doesn't apply to any of the folks who are listening to these presentations of 500 or more employees.
Okay. The next question that came in, what if their spouse is at home and can watch the kids?
So if your spouse is, so remember, the employer cannot require your spouse to watch your children. If there is if you have telework and you have work for your employee and you have plenty of work for your employee, then your employee really should be working and should not apply for or require these benefits. But you can't inquire, because it would be discriminatory to say, hey, you're a guy, don't you have a wife working at home? Why can't you come into work? That would be discriminatory under a lot of various laws, both under federal or state. So what you can say is, I've offered you telework, here's telework, and then wait for the employee to give a reason as to why they can't do telework and why they need to go on. And one thing I should also add that I realized I didn't touch on is there's something called intermittent, okay? And this applies both in regular times and times like this. So for instance, under the under the Family Medical Leave Act, in regular times, you can have intermittent leave. So the leave does not have to be continuous. You could be a day on, a day off. Same thing under this Families First Coronavirus Response Act. You could have a situation where an employee says, okay, I can come in Monday, Wednesday, Friday, but I can't come in Tuesday, Thursday. I need to watch the kids Tuesday, Thursday, but I can come in Monday, Wednesday, and Friday. So on Tuesday and Thursday, then you better pay the paid, the paid leave. And when that paid leave is exhausted, those 80 hours of paid leave or the equivalent to a part-time employee, then, then the FMLA or the Family Medical Leave under this new coronavirus law would kick in. But if they can work on an intermittent basis, then by all means, they should work.
Okay. Next question is, what if you furlough the employee?
Furlough.
Yeah.
So if you furlough the employee, this is something else that went into effect on Friday. In this big stimulus law that was passed, There's also enhanced unemployment benefits. So first of all, in states across the country, they are relaxing their applicability requirements for applying for unemployment. So for furloughed employees, they should definitely apply for unemployment benefits, and now there will be enhanced unemployment benefits. I don't know, because the guidelines have not come out yet, and this would be state by state, if the employer's contribution rate is going to go up as a result of more people going on unemployment. But I know the employees who are furloughed are going to be entitled to unemployment compensation benefits. Now, if you want the tax benefits under the new coronavirus laws, then bring those employees back and pay those benefits to them. But if you don't bring those employees back and you do furlough them, then they are entitled to collect unemployment. And you also might have to pay them for any accrued unused vacation that they have. So I would check your local laws to see if for those employees that you do decide to furlough, that you provided, if you're big enough, the COBRA notice, which applies to 20 or more employees, or a lot of employers who don't have 20 or more employees. There's a state law that would be like a mini COBRA law. So you've got to provide the health insurance if you provide the health benefits to them, and also any accrued paid time off you would have to pay if you decide to furlough those employees.
Okay, the next question. Sorry, can you elaborate on the April 1st deadline? What changes after that?
So the April 1st is when the Families First Coronavirus Response Act goes into effect, which is why I said, if you're concerned about retaliation or discrimination provisions and you think you're on the cusp, should I keep my employee, should I not, should I keep him, should I not, should I keep him, should I not, I would figure it out before the law goes into effect on April 1st, the Families First Coronavirus Response Act, because later on down the road, you don't want to have the allegation that you discriminated or retaliated against your employee for either requesting the benefits, or you discriminated in terms of you provide some employees with benefits, but some you terminated, and you discriminatorily applied who would get those benefits and who would be laid off. And that's why I said, if possible, I would figure it out now before the law goes into effect.
Okay, next question. If we are a dental office and we are doing emergency patients, so we're seeing emergency patients, but we are not working the same amount of hours, do we have to pay the employee up to the same hours they received before?
You have to pay your employees for all hours worked. If you have some employees who, for instance, I think what you're really getting at is, we have some employees who, before we're exempt, they received a salary. And I think that's what this question is getting at. Because first of all, under the law, you always have to pay your employees for the hours they work. But if what you're referring to is you have an employee that's exempt from overtime, and they are only working a few hours and they're not working full time, so do I pay their full salary for that week? I would say, if you don't want to be worried about blowing your exemption, you might want to pay that, or you might want to, again, they would be entitled to some of these paid leave benefits. So I would be really worried though, if you cut what I would do instead is I would actually cut the salary in general. You might want to consider that. So I would say, you know, times are tough right now. Before, let's say you were paid a yearly salary of, you know, $100,000. Now we're going to pay you a salary of, you know, $50,000. And what you might want to consider is actually, you know, cutting the salary, but still paying the full, the same weekly benefit if they're going to be working a certain amount of hours, so you don't blow your exemption, and unwittingly then they turn into a non-exempt employee when they were exempt before.
Okay, so the question was just clarified. You're talking about hourly work. Okay. Do they need to get paid for the same number of hours as they were working previously?
I would pay your employees for, if they were hourly, you just, like before, you pay them for the hours that they work.
Okay. And someone else responded, if employees are salaried and they're not exempt from overtime, then I guess that would be what you just discussed.
Yes.
Okay. The next question. I have 5 employees and one of them is pregnant. I told all of them to apply for unemployment until we go back to work. Our last day of work was March 18th. Do I have to continue paying the pregnant assistant?
you would not have to treat a pregnant employee any differently than any other employee as long as you are not discriminating on the basis of pregnancy. So for instance, when it comes to all these various laws that I discussed, whether it be FMLA, pregnancy, discrimination, etc., if and this happens actually regularly when it comes to job eliminations. And I see these when let's say companies aren't doing well and they have to lay off folks, and then the question becomes, I have a person on FMLA, do I lay off this person or not? Well, if the person was not on FMLA and you could justify a legitimate business reason that you would have laid off this employee had they not been on FMLA, then you could still lay off that employee. But you better make sure to have that documentation and not treat that employee any differently as a result of that person being either on FMLA or pregnant, etc. But yes, if you would have eliminated that position, irrespective of the pregnancy, you can lay off that pregnant employee because the pregnant employee doesn't have any more or less rights than that employee would have had they been, working or, or not. You just can't treat employees differently on the basis of the pregnancy.
Okay, next question. Some of our employees are applying for unemployment. What happens if I ask them to help with emergencies? That could be up to half a day long.
Okay, as with most unemployment entities, you've got to certify every week whether you received any income or not. And so the benefits that they might receive in terms of wages might be offset by some employment that they might receive while they're on unemployment. Because you basically have to call in and certify every week, did you earn any wages this week? How much did you earn? And so their unemployment might be reduced by the amount that they earned if you call them in for the emergency.
Okay, but they would still be considered unemployed, technically.
They would, yes, they would be, because they're not receiving their usual, compensation, unless they're receiving a certain threshold. If they're receiving above a certain threshold, then yes, they would not be eligible for the unemployment benefits. But let's say, you only bring them in for 2 hours and they normally work 40 hours a week, and once a week they work 2 hours, that is less than the threshold, the unemployment threshold, and so they would be entitled to receive a certain amount of unemployment compensation benefits. And this assumes you're not paying them any of the other, the benefits under the first, the Corona Act, because they can't receive both. They can't receive both unemployment and the benefits under, Corona.
Okay. Next question. I have 3 employees, only 1 full-time, who got sick last week but cannot confirm if it is COVID-19. I am planning to terminate or furlough. What do I do with the one that is sick?
So the person who was sick, you should continue to pay that individual up until the time you furlough all of your employees. And then again, that goes back to it's similar to the other question that was asked. If and when that employee is not entitled to any additional benefits that any other employee had, that person not been sick. And so you would continue to pay that person until you decide to, furlough. But what you can't do is you can't say, oh, that person is sick and the other people aren't sick, so I'm going to continue to give some telework to the other people and continue to pay them, and I'm not going to pay that other person who was sick, or decide that's the first person I'm going to furlough because they can't provide any benefits for me anyway. You will then have just opened yourself up to a discrimination claim.
Okay, we've cleared the question backlog currently. If anybody has additional questions, they could type them in. While that's happening, I'm going to repeat some of the points I mentioned at the beginning regarding the CE. The CE will be sent via email within around 2 weeks, so check your email boxes and please be patient. The webinar is being recorded, so if you missed a past webinar or you can't attend an upcoming webinar, or you would like to share this webinar with somebody else, they could watch the recording, they could complete a 10-question multiple choice test, and they will receive their CE credit. We do have another webinar scheduled for later today by Dr. Russell Schaefer at 1 p.m. Eastern on denture fabrication. Okay, there's a few questions that are coming in, so we will field those and continue. What is the legal differences between furlough and termination?
So furlough is actually a word that's usually not used in this context. It's usually used in the context of unions and labor issues. We've seen it a little more so now in this context, but furlough generally means you're temporarily not working because of certain economic conditions. And then when those economic conditions change or whatnot, then you are brought back to work. And so when you apply for unemployment compensation benefits, a lot of times unemployment will ask you, are you laid off? Are you furloughed? Or have you been terminated? And then if you see terminated, they'll ask for the reason why, because they will want to see if the termination falls under some kind of specific category or whatnot for unemployment, if you're truly entitled to benefits or not, if the reason was. So it's essentially a termination, but it really means in the furlough context that you're probably going to be brought back. And so usually furlough is used in construction industry, which is very, very seasonal. Usually for employers, we usually don't use the word, I don't mean employers. Usually for professionals, we usually don't use the word furlough. We usually use, laid off. So generally furlough is more a union terminology.
Would that be equivalent to unpaid leave?
Unpaid leave, no. That's different, because for unpaid leave, so really unpaid leave, you're talking about a leave of absence. A leave, when someone's on, let's say, a leave of absence, they're still employed, and they're probably still entitled to certain benefits under an employer benefit plan, such as health insurance benefits paid for by the employer, as long as the employee continues to pay the employee share of the health insurance benefits. Maybe it's because of like a leave, like a military leave, or they're sick, or they're on short-term disability, long-term disability. That's usually a leave. Furlough is different. It's really, you are terminated, but for a short period of time. And furlough also comes in the context, which probably is not applicable here, but I'll mention it anyway. There's another act called the Warren Act, W-A-R-N. It's a federal law, and also states have similar type of laws. And if you're an employer of a certain size, a larger employer, if you're going to lay off a certain amount of employees in a given period of time, if that layoff is going to be 6 months or more, you've got to give certain notice requirements. And so usually furlough refers to a shorter term leave. You're going to bring that person back in less than 6 months. And so you don't have to provide that, 2 months of paid, 2 months of notice leave under the Warren Act. And so that's why, furlough usually has certain other implications used in different contexts of the law. But usually, as I said, in the employers that I deal with, we don't even usually use the term furlough. We usually are, terminated, separated, or laid off, really.
Okay, the next question. The CARES Act provides for an additional $600 weekly benefit on top of the state benefit. If an employee receives partial unemployment benefits due to reduced hours, will they still receive the entire additional $600 weekly benefit?
So that's a question I really can't answer yet, because I have to get a little bit more up to speed on the CARE Act. I know that the CARE Act is designed between both the $600 under the CARE Act and your state's unemployment to be able essentially to be full pay, because the unemployment rates are usually pretty low weekly. And I know the CARE Act is meant to bridge that gap so that employees truly receive their weekly compensation. My educated guess is if you do work for a certain amount of hours, for any unemployment that you call, they're going to ask you if you did any work, and they're going to offset the number of hours you worked, because it shouldn't be a windfall. You shouldn't be receiving more than you normally would have been entitled to receive. So there is going to be a set off. The specifics of the CARE Act, I have to get up to speed on.
Okay, next question. If we terminate all employees before April 1st and hire some back on an as-needed basis, would they still be covered under the Act?
When you say under the Act, are you referring to I would guess I need to know which Act you're referring to. The expanded family medical leave under, Families First Coronavirus Response Act. Are you referring to, what Act are you? Yeah.
The expanded.
Okay, so again, if you bring certain employees and you pay them because you have some work, and then you don't have any work, you don't necessarily have to apply the expanded family medical leave. That's really if you're essentially going to keep on some of your employees and not essentially temporarily lay them off, or if you want to use the term furlough. If you decide that you do want to essentially stay open, then you need to provide those benefits for your employees.
Washington.
Yeah, sorry, go on.
Go ahead.
But then you do run the risk, you always run the risk later on, if, you know, of an employee coming back and saying, hey, listen, you really were open this whole time. You really could have given me these benefits. Why didn't you give me these benefits under the law? Were you trying to subvert the law? And so you could expose yourself to liability if you really do, you know, that's why I said you have to think about it carefully. You have to think about your staffing needs. So if you think you're going to really need a good amount of your staff, more so than not, I would think about providing these benefits for the hours that they don't work. So the paid sick time for the hours they don't work, because if you don't do that, then you can later open yourself up to disability or discrimination claims that, hey, we asked for these benefits, you pretty much stayed open this whole time. It wasn't like you had, you know, one emergency case in 2 months. You know, you basically were going to work every day, and you should have provided us with these benefits as you were required to do under the law.
Okay. Washington State calls furlough standby. Can employees that are on standby apply for the 12-week or the 2-week FMLA?
So again, if your employer is open, and again, I don't know the laws in Washington, so I can't really, I can only just really give a general answer. And again, I would check with your local attorney to actually get legal advice. I'm just providing general information. I'm not, you know, giving legal advice. Generally speaking, if you are keeping someone, let's say, on standby or whatnot, and you're staying open, then you might have to provide some of these benefits. I think that was a question, right? The question was, if I have employees that are sometimes coming to work, sometimes not coming to work, and I have them essentially like on call, do I have to provide these benefits? You might. And I would check with your local attorney.
He actually says that Washington State equates furlough to standby. And then he's asking if the standby applies for the 12-week or the 2-week FMLA.
So I would say it depends how you categorize your employee. Are you categorizing your employee as being employed at this time, or have you terminated the employee and the employee is applying for unemployment compensation benefits? If you have closed up and you are not providing services to patients, then I would say your employees are not employed, and they should be applying for unemployment compensation benefits. But if your office is open and you are continuing to service patients, and you have some employees that are providing services and you continue to provide services, then I would think of providing the coverage under the FFCRA.
Okay, so for the next question is, so for those who are not going to be receiving unemployment benefits, should they be let go before April 1st? They should be terminated and not just decrease in hours. Is that correct?
Well, if you feel your office is going to remain open and you have staffing needs, there's nothing wrong with decreasing the hours or decreasing salary, and then providing some of these benefits. Because if you do keep your employees, you can apply for a loan and also their tax credits. So I would, you know, employers are doing, I've advised a lot of our clients to do different things. I've advised employers to cut wages, reduce salary, but also, you know, if they do want to get these benefits, especially the loans, you know, then you've got to keep your employees.
Okay. If you have an employee that got an order from her doctor not to work because of her pregnancy, a week before we closed the office because of Corona, she stated to claim her short-term disability. Is she able to claim unemployment as well?
Is she receiving short-term disability?
Yes,
From a short-term disability?
Yes.
So if she's receiving short-term disability, you can't double dip. You either get your short-term disability benefits or you get your unemployment compensation benefits. Unless there's something else in that jurisdiction that might apply. So again, you might need to check your local council, but as a general concept, generally someone cannot get both short-term disability benefits and unemployment compensation benefits. And unemployment is going to ask, are you getting any other weekly benefits? How much are you getting? Because for instance, let's say someone gets hurt at work and they're getting workers' compensation benefits. Generally, the workers' compensation benefits are higher than the unemployment insurance benefits. And they rather have their workers' compensation than unemployment. And you can't double dip. So usually it's either one or the other, unless maybe there's some local law that allows you to collect some or both of each. Or perhaps if the short term isn't up to a certain level, maybe you can collect some unemployment, but I highly doubt it. Generally, you can't double dip.
Okay. We are required to open for emergencies. Are you recommending that we just shut down?
When you say you're required to open for emergencies, is this because of government regulations you're required to open for emergencies? Or, I mean,
that's my understanding of the question, yes.
I mean, if you're required to open for emergencies, then you might have to continue to service some patients. You will need to keep like a skeleton crew on standby. I'm not using the word standby like it's used in Washington because I don't know what the definition is in Washington. I'm just using that colloquially.
Yeah, it's a government directive that they need to be open for emergencies.
So my guess is you probably need to keep some people on staff to field those phone calls. And so you might want to have some of your employees work in shifts. So maybe, as I said, work intermittent, either give some of the intermittent benefits or, unemployment, have the individuals apply for unemployment as you stagger out your schedules, or you just keep, one person. That's a business decision you're going to have to make. But if the government is requiring to stay open for emergencies, you'll have to figure out how to fit that requirement, unless you want to, as a business, make a decision to completely close as a business. And then you would have to somehow establish to the local authorities, if you're ever questioned, as to whether you truly closed down or not, or you just closed down in name to avoid following the law. And that could have certain repercussions.
So that means we cannot furlough before April 1st. That's the follow-up.
I didn't say that.
Okay,
if you want to, at any time, a business can lay off employees. So let me clarify. What I meant by April 1st is the new law, this Families First Coronavirus Response Act, goes into effect on April 1st. That's when this new law goes into effect. You can start paying benefits under the Families First Coronavirus Act from April 1st going forward. It's from April through December. As you see on the top part, I don't know if my handout is still open, April 1st, 2020 through December 31st, 2020 is when these provisions will apply. So you have to provide this paid sick time, and you have to provide the family medical leave from April 1st through December 31st. And along with this law are, like in any other law, provisions against discrimination or retaliation. So people who ask for these benefits, you can't discriminate against them. You can't discriminate how you provide the benefits, that you provide it to some employees, not other employees. And you can't retaliate. If someone asks you, let's say in June, let's say most places have opened back up in April, but somehow a person gets sick in June and you really are fully functioning in June, and someone says, hey, I need to take these benefits. You can't retaliate against them by saying, sorry, you're fired. That would be retaliation. And so what I meant by this April 1st deadline is that to prevent yourself from being in the situation that you will have violated this law by retaliating against an employee who has asked for these benefits, or discriminating against employees by picking only certain employees that you will provide the benefits to or not provide the benefits to. If you truly think you cannot keep all your staff for financial reasons, I would say figure it out before this law goes into effect, so you don't have to worry about future litigation or exposure from the retaliation or the discrimination provisions of this law. That was my point with regard to figuring it out, whether or not you want to terminate someone or lay them off before April 1st. So I hope I clarified that point.
Yes, thank you. If we have less than 25 employees and want to apply to be exempt from the FMLA benefit, should we go ahead and put that out to the employees, or would that benefit would jeopardize our business and put that in writing? Should we wait to hear from the DOL on how should really qualify to be exempt? Doesn't it seem contradictory? This is a long question, sorry. Doesn't it seem contradictory that the SBA will forgive loans that pay for payroll to keep employees working if we say it will jeopardize us?
So that's a great question. And that's a question that unfortunately right now, no employment lawyer really has the answer to, because in this Families First Coronavirus Response Act, it says that, employees with 50 or less employees, if it jeopardizes the viability of their small business on an ongoing basis, that there's a small business exemption. But only the Department of Labor, the Secretary of the Department of Labor, is going to issue guidance as to what constitutes this small business exemption. And they haven't issued the regulations yet, so no one knows. No one knows what truly is going to trigger it or not. And in the same, if you look in and you research the Department of Labor requirements, they also say, like in their FAQs, their frequently asked questions, don't write to us, don't ask us, is this something that qualifies for the exemption? So they're still working on these regulations. They don't know. And because they don't know and they're not giving us information, it's hard for us to advise. But what I would say is document very carefully, really document on a daily basis. So I had all these patients yesterday, but I have no one tomorrow. Here's our financial situation. I don't think it's viable. But on the same token, with these loans, they're giving huge incentives to employers to keep their staff. They're basically saying, we're going to give you free money because we are going to, forgive these loans if you take loans out to keep your staff. So if you keep your staff, if you're able to weather the storm and pay and take out a loan, it's going to be forgiven. And so, who knows if then you'll be able to later say that it jeopardized the viability of the business by not complying and providing the paid time off and the family leave. So no one really has the answers to these questions yet.
Okay. Next question. Can I do some elective services while I am seeing emergency patients?
I don't see why not. I mean, when you say elective services, I assume, cleaning teeth, whatnot. These are, I know a lot of physical therapists have continued to provide physical therapy services up until last week. Some are now saying that they're not going to, but others are continuing. So I would certainly say if you have patients who are willing to come in that have a history of poor hygiene or certain dental problems, I would certainly continue to service them in a very, very safe manner. And you have to make sure that you are not exposing your employees to any risks. So, you have to have the 6 feet of distancing, which I know is hard to do if you're over someone's mouth. But you have to watch that with your staff. If it's not necessary for them to be close to your patients, keep them 6 feet away from one another, maintain the social distancing, provide the protective gear that you're required to provide, because also, if God forbid any of your employees contract COVID-19 while working in your place of employment, they could file workers' compensation claims or others. And if other patients, for instance, contract the disease, they can later sue you for negligence and or sue the business for negligence. So if you are going to stay open, you do have to be very, very careful to put various policies and procedures in place to ensure the health and safety of your employees, but also your staff.
Okay, we took care of the questions that came in. Helen's contact information is on the handouts. So the handouts were distributed via the chat, the webinar chat, and they're also available.
Oh, one more thing. I'm sorry. Very, very important that I almost forgot to tell you. Really important. The handout about the Coronavirus Act, where it says employees' rights. And I mentioned this a little bit in the beginning, and I forgot to mention this. I said I'd get back to it in the end of my presentation. there are a lot of laws that the government, both federal and local, have required us to post in our place of employment. So the Fair Labor Standards Act, by federal law, you've got to post that poster. There are various state laws that require you to put up posters about certain laws. This employees' rights is one of them. That's why I gave you this. I was gonna actually include the coronavirus in my own handout, but I said, you know what? Forget it. The Department of Labor came out with another poster. It's this employees' rights one, and that's why I included it, and it didn't include it in my outline. You are federally required to post this employees' rights one-page sheet in your place of employment in a conspicuous place where employees can see it while it applies through December 31st, 2020. So that's why I included it. Now you've got it. You don't have to search for it. You are federally required to post this in your place of employment along with all of the various other posters that either by state, local, or federal law you have to post.
Okay, very important point. Okay, so Helen's contact information is on the bottom of the outline in the footer, maybe in the header as well. So she's available to be contacted via email or phone with additional questions. If you're watching this recorded, then click on the link below, complete the 10-question multiple choice test so we can send you the CE. And if you're watching it live, we'll be sending you the CE directly to your inbox. And we do have another webinar coming later today, 1 p.m. Eastern, so we hope to see you there. Helen, thank you so much for your time and all this valuable information. And we hope everybody is able to weather the current situation, both from a health and economic situation. So we wish everybody the best, and everybody should come back stronger from all of this.
Agreed. Thank you for having me.
Thank you, everybody, for attending.